A judge points at you and says one word. Contempt. 30 seconds later, you're in handcuffs. No jury. No trial. No appeal. This power exists in every American courtroom, and here's exactly how it works. Every courtroom in America operates under an invisible rule that most people never think about until it's too late. The judge isn't just a referee. They're the absolute authority in that room. And they possess a power that dates back centuries, a power that can strip away your constitutional rights in an instant. It's called contempt of court. And here's what makes it terrifying. Unlike every other crime in America, contempt doesn't require a trial. It doesn't require a jury. It doesn't even require you to know you've committed it. One moment you're standing in court, maybe as a witness, maybe as a spectator, maybe even as the lawyer. The next moment, a judge says that single word, and everything changes. But here's the question that nobody wants to answer. How did judges get this extraordinary power in the first place? The contempt power traces back to medieval England, when the king's courts needed absolute authority to function. Judges were extensions of the crown itself. Disrespecting them meant disrespecting the king. And disrespecting the king meant immediate punishment. When America's founders created our legal system, they faced a problem. They wanted courts that could actually function. Trials that could proceed without chaos. So they kept the contempt power, but here's where it gets complicated. There are actually two completely different types of contempt, and they work in entirely different ways. Civil contempt is about forcing compliance. Refuse to pay child support. A judge can jail you until you pay. But criminal contempt? That's about punishment. And this is where the real power lies. If you think that's concerning, wait until you hear about the most extreme form. Summary contempt. This is the version that lets a judge skip everything. Now imagine you're standing in a courtroom. Maybe you're a witness. Maybe you're just in the gallery watching a friend's case. The judge asks a question. You don't answer fast enough. Or you sigh loudly. Or you mutter something under your breath. The judge looks directly at you. And in that moment, everything you thought you knew about your rights vanishes. Summary contempt means the judge witnessed the behavior themselves. They don't need prosecutors. They don't need witnesses. They don't need anything except their own observation. And here's what shocks most people. The same judge who witnessed your behavior is the same judge who decides your guilt and the same judge who determines your punishment. Let me put this in perspective. If a police officer witnessed you commit a crime, they couldn't convict you themselves. They couldn't sentence you themselves. But a judge can do all three, instantly. In 2004, an attorney named James Ware stood before a judge in a routine hearing. The case wasn't particularly dramatic. But when the opposing counsel made an argument, Ware rolled his eyes. That was it. One eye rolled. The judge saw it. And within 30 seconds, Ware was cited for contempt. The punishment? 6 months in jail. For rolling his eyes. Think about that for a moment. 6 months of your life, gone. No jury ever heard the case. No prosecutor ever argued it. The judge who saw the eye roll was the same judge who decided it was contempt and the same judge who imposed the sentence. But here's where it gets even more unsettling. There's almost no limit to how long a judge can hold someone for contempt. The longest documented case involved a man held for 14 years. And it was technically legal the entire time. But that's not even the most troubling part. What I'm about to tell you changes everything you think you know about constitutional protections. Here's the reality that law schools barely mention. When a judge cites you for contempt, several of your fundamental rights can simply disappear. The right to a jury trial? Gone in summary contempt cases. The right to confront your accuser. The judge is both the witness and the decision maker. The presumption of innocence. Effectively reversed, because the judge already saw what happened. Even your right to remain silent can work against you in civil contempt. Refuse to testify? That's contempt. Refuse to hand over documents? Contempt. Refuse to do what the court ordered? You can sit in jail indefinitely until you comply. This is the legal system's most concentrated form of power. And here's what almost nobody talks about. Judges rarely face any consequences for overusing it. And this is where I need you to pay close attention. High-profile cases have exposed just how far this power can reach. In 1996, a journalist named Vanessa Leggett refused to hand over interview notes to a grand jury. She believed her sources deserved protection. The judge disagreed. Leggett spent 168 days in federal detention. That's 5.5 months in prison for protecting her sources as a journalist. No criminal trial. No jury. Just a judge's order and immediate imprisonment. Or consider the 2011 case where a judge held a man in civil contempt for failing to decrypt his computer. He claimed he forgot the password. The court didn't believe him. He spent years behind bars, never charged with any crime, just contempt for not producing information he said he couldn't provide. The question everyone should be asking is, where does this power actually end? Here's the answer that most legal experts won't say publicly. The limits are surprisingly thin. The Supreme Court has ruled that for serious contempt, you do have the right to a jury trial. But here's the catch. Serious means more than 6 months. So a judge can sentence you to up to 6 months in prison with no jury at all. And for civil contempt, there's theoretically no limit because it's not considered punishment. It's considered coercion. You hold